the FOX6 studios, this is Ask Contact 6. This is a segment where we bring in experts to answer your questions. Today, our topic is small claims court. We chose this topic because we know consumers and tenants can find themselves in difficult positions and end up in court as a last resort. We realize there's a lot people don't know about how the process works. So to answer your questions today, we have two experts joining us. Both are from the Legal Aid Society of Milwaukee. First, we have managing attorney Nick Toman joining us. Nick, thank you for being here.
Glad to be here. Thanks.
And we also have staff attorney Mitch Yurkowitz here answering your questions. Mitch, thank you for joining us as well.
Thank you so much.
Of course. So before we get started, Nick, can you explain a bit about the services the Legal Aid Society provides?
Sure. We serve low-income Milwaukee County residents in civil legal matters. So we have, we really have two offices. We have an office at Children's Court, and we have attorneys who are guardian ad litems for children who are involved in termination of parental rights and other cases out there. We're appointed by the courts out there. And then we have a downtown office, which has our civil division, which is composed of the housing team, which Mitch and I are on, which primarily we handle eviction defense. We have a consumer team that handles a lot of debt collection actions in small claims court, bankruptcies, and other matters, so student loans and things like that. And then we have what we call our health and wealth team, who handles Social Security, disability appeals, some end-of-life planning, estate planning, and some work with pardons and expungements for criminal cases. And then we also have some guardian ad litems in divorce court for custody matters. But generally, we spend a lot of time in small claims court, helping a lot of people primarily on the defense side, but not exclusively. And we hope we can share some of that knowledge.
That's a lot of ground you're covering. I appreciate you bringing your knowledge here today. Mitch, I know you're also involved in something called Eviction Free MKE. What is that?
So Eviction Free MKE is a program that was started about 3.5 years ago in order to try, at least attempt to prevent evictions in Milwaukee County. The side of that we are on is the legal side. So we provide free legal services to tenants who are dealing with eviction cases. Specifically, we're only in Milwaukee County, trying to either provide legal assistance to help them move on from the case or defend the case fully if that's what's necessary, depending on the situation. So that's eviction free. We're trying to at least limit the number of evictions in Milwaukee. And ideally, we'd like to get that down to zero at some point. Obviously, that's a lofty goal, but that's what we're aiming towards.
And we do have some questions about evictions today, so I'm glad you're bringing that knowledge here. We are going to get to questions in just a moment. First, we are going to do things a little differently today. We thought we should start with a discussion or an overview of how small claims court works in Wisconsin, what it is, and then we'll move on to questions about specific cases. Also, Nick and Mitch will do their best to answer your questions today based on the information we have. But for more advice on a specific situation, you may want to seek guidance from your own attorney or call the Legal Aid Society directly. So let's get going. Reading our questions for us today is our Contact 6 associate producer, Annette. We're going to get to her in just a moment. But first, can we explain what is small claims court? What kind of cases are handled there in Wisconsin?
Sure. Small claims court is a special court that's set up, authorized by the state legislature and the statutes to handle specific case types and lower dollar amount claims.
Under $10,000?
Generally under $10,000. There are some exceptions. It's $5,000 for contracts and torts, I think, but generally under 10. And evictions. All evictions are heard in small claims court, no matter what the dollar amount. That's probably the one exception to the dollar limit. Small claims court uses a relaxed set of evidentiary rules. Hearsay rules aren't really in play, and there's not as many formal procedures as there are in large claims court or criminal court. It's intended to be a more accessible and approachable system for non-lawyers, so that claims that are not quite as expensive and going to be brought by parties who can afford to hire attorneys can hopefully manage their cases on their own.
So, do people need an attorney for small claims court? Because we get that question quite a bit.
You don't need an attorney for small claims court, but if I'm being honest, I would probably recommend people get an attorney for small claims court if they can. A lot of the rules are relaxed, but all of the rules can't be relaxed. There's some rules like serving the other party with the court papers that the court just can't be changed because it's so fundamentally important that both parties know that there's a lawsuit going on, that the formal rules are still in effect. And there's also a lot of scenarios I find where just the separation from the case and the emotional distance is almost necessary to really fully evaluate the case. I know Mitch has had a situation very recently, and we all have, where an unrepresented landlord in our examples makes decisions that are probably worse off for both the landlord and the tenant, just because they're not really fully seeing the big picture. So I would always recommend that someone get a lawyer when they're heading to small claims court. It's not completely necessary, and people can definitely get by with some brief legal assistance from some Milwaukee Justice Center, for example. But it's probably a good idea to have some professional advice.
Right. And you provide services for free, for a low cost?
We do for Milwaukee County tenant or Milwaukee County residents. We can help with a number of cases that are case types that are heard in small claims court. And then there are some other organizations like the Milwaukee Justice Center, the Marquette Volunteer Lawyers Clinic, who can provide advice as well for case types that we don't handle, or for people who are above our income limits.
Right. I know evictions obviously fall into small claims court. Something we hear a lot about are issues maybe with contractors, people who pay a contract for work that isn't completed or even started. They could file a case in small claims court as well. So various types of money claims can be heard in small claims court. I also want to ask about fees, because I know money is very important to some people. It's one reason they may think they could go without a lawyer. Would you tell us a bit about the fees for small claims court?
Yeah, absolutely. So in order to file a case, you do have to pay the fees just to do that. I believe it's $189 to file a complaint, although I could be wrong on that. I think that's actually changed recently. And you also have to, you likely will have to pay to serve the other party. So there are ways to do that relatively cheaply. There are process serving companies, but that is another fee that you would likely have to pay in order to start that claim. There are fee waivers available. So if you are under the income limit for that, if you receive food share specifically, I know is a common way that a lot of people qualify for that. You can receive a fee waiver in order, and that actually does apply to the sheriff as well. So the sheriff is allowed to serve parties in Milwaukee County. If it's in a different county, you would have to contact that county and see exactly how to do that. But within Milwaukee County, the sheriff can serve and accepts that fee waiver. So that way it is a little bit cheaper if you are under those income limits. But again, it's $200+ in fees just to get into court.
Can you explain how you go about filing a case? Do you need to have a lot of documentation? Can you do it online, or do you have to go down to the courthouse? How do you go about taking that step?
So, I would really recommend, if you're going to do it on your own, which I don't necessarily recommend, I do recommend if you have a case, if you can, contact legal aid, contact one of these other organizations that are available to help people. I would really recommend doing that. But if you are going to do it on your own, or if you're over our income limits or whatever, there are a lot of resources online with documentation on how to help with that. You can file it. You don't have to do it online. You can do it on paper. People still do that. However, then it's harder to get notified about upcoming court dates and things like that. And then you have to physically go down to the courthouse in order to file any documents for your case. So you absolutely can do that, but it does come with some difficulties there. So you can just file it online through the e-filing system. What you have to do is you have to fill out the complaint with all of the necessary facts and exactly what you're looking for out of the case. So there's the forms for small claims actually have little check boxes on exactly what type of claim you're going to be making, whether it's an eviction or a different type of small claim action, personal injury, tort, whatever it is. So those check boxes pretty much lay it out. You have to fill out exactly what the facts are that support the case. That can be a little bit complicated, and exactly what facts are important is often difficult for people to determine, because really the court doesn't care about the whole thing. They care about what matters for the case. So especially with evictions, they don't want to know, everything that's ever happened. They want to know why this case is happening. So you have to fill that out. And then you have to go to the clerk of courts, file probably room 104 in the Milwaukee County Courthouse at least. And that's how you get that case started.
Nick, did you want to add anything?
Yeah, I just wanted to add that there are very specific forms that are required to file. And so you want to make sure that you're getting the right form for Milwaukee County. If it's Waukesha or Ozaki, it likely may be a different form. There are bilingual forms required in Milwaukee that aren't required in other counties, so it might be different forms. So you want to make sure you get the right form. The other thing when you're filing initially that I think is worth mentioning is that it's very important that you get the right party to sue, because this becomes an issue if there's an LLC involved or if it's a company with a name that's different than the individual with the assets, and then you need to figure out where they are served. So if it's an LLC, you need to go to the DFI website. It's a little tricky right up front, figuring out the right party to sue and where to contact them. And then I think your question was whether or not you need a lot of documentation in order to file. And the truth is, to file, you don't need that much documentation because you need to allege the facts that you're going to prove in court. You don't need that documentation as part of your initial filing. That's the evidence that you're going to present later. You have to allege the facts that give rise to your right to whatever remedy, whatever money you're entitled to. The documentation doesn't come until later. So,
and I assume the more you have, the better.
Once you're getting into court and you have to prove up your case, the more evidence you have, the better. The more documentation you have, the better. I mean, testimony is admissible evidence, but if all you have is oral testimony without any documentation or paperwork or pictures to back up your case, it's going to be harder to convince the court of what you need to convince them of.
So let's say you go ahead, you file, you appear for court. Is it usually on Zoom or is it in person these days?
It is not on Zoom anymore.
Okay, so you appear in court. What happens if the defendant doesn't appear or doesn't show?
Assuming that you have, as Mitch discussed, served the defendant with the papers, either presumably with the county sheriff doing the service or some other process server, party's not allowed to serve them themselves. So that's probably worth noting that it has to be a process server. A party can't serve the other party. Yeah. If you have the paperwork that proves that you served them and did it the right way, and the defendant doesn't show, you most likely get what's called a default judgment, which is what you're asking for. Now, you're going to be in front of a court commissioner in small claims court in Milwaukee County, at least. In other counties, it might be a judge immediately, but in Milwaukee, Waukesha, I think Ozaki, Washington, I know Milwaukee and Waukesha, you're in front of a court commissioner the first time you go to small claims court. They're going to look through the paperwork and make sure that you've alleged everything you need to allege, that you have the papers that you need, and there's a list of papers you need, like an affidavit of non-military service that the defendant isn't overseas in the military, to the best of your knowledge, that you've served them with the papers, that all the paperwork's straight, and that the complaint alleges facts that are an actual legal claim. I mean, you'd be surprised how often people file a small claims lawsuit for something that just is not in any way a recognizable claim or lawsuit. That there's just, I mean, it's just wronged me in some way, but it's not really a legal claim. The commissioner is going to look through all that, and if everything's in order, they'll give a default judgment for the amount that was requested in the summons and complaint.
Does the defendant have a period of time they can fight that default judgment? If they say I got sick, I had a family emergency, I couldn't make it.
Statutes allow for up to a year to reopen a
Okay.
default judgment of small claims, but you have to have cause. You have to have a very good excuse as to why you didn't appear in court, and you have to be able to allege that you have a defense of the action. The courts don't like people coming to reopen judgments when there's no reason that the judgment shouldn't have been entered in the first place.
So when it comes to evictions in particular, are there notifications that have to happen before the filing is made, and what are they?
So before you can file an eviction claim, the landlord will have to send you will send the tenant a termination notice. That termination notice might be a 5-day, 14-day, or 28-day notice. It's important to note that notification, that termination of tenancy, can be served by them personally. They can hand it to you. They can try 3 times and then put it on your door, and they can also send it via certified or registered mail. There's a part of the statute that specifically says that if they send it via certified mail, that is sufficient. So even if it doesn't get to you, your mailbox doesn't work, you check your mail every day, but it's not there, or you just forget to check your mail for a little while, even if it doesn't actually get to you, that still counts as sending the termination notice. So it's important there to note that notification technically doesn't actually have to get to you. It doesn't feel really correct, but that is the situation with termination notices. In addition to that, they would also have to serve you, as we talked about earlier. Again, and this is also specific somewhat to evictions, that you cannot dodge service the same way that you can in other cases. When it comes to evictions, they are allowed to serve the property itself. It's called in rem jurisdiction, or at least that's the Latin term. Really not that important to understand that fully, but basically the idea is if they try 3 times, post the complaint to the door, and the sheriff or whoever is the process server testifies to that, or makes a declaration or an affidavit to that, that is sufficient to get an eviction in small claims. So you can't use that for money claims. So that gets a little bit tricky. They would have to publish and do that in order to get money claims later. But as far as the eviction goes, you technically do not have to have actually received any of that paperwork. So it's really important to be checking your mail if you're worried about an eviction. Check your door if people are knocking on it, because you can't dodge service the same way. And in addition to that, legal aid frequently sends out letters to tenants if we see their cases on CCAP, the public access for court records. And that is how we get a lot of our cases. So a lot of people, the first time that they know that they're getting evicted are from our letters to them. So that's very unfortunate. But if you get one of those letters, if you are at risk, contact legal aid and the Rental Housing Resource Center immediately. The earlier you get to us, the more likely we are to be able to help. And even if we can't help, we can at least point you in the right direction, or we can tell you, come back to us when we can help, or something like that. So it's really important to know that, again, technically you don't have to receive it. They do have to send it, but it doesn't actually have to get to you.
Let's say I'm a tenant who has an eviction filed against me. It's upheld on the court day. How long is that going to stay on my record for?
So if it's just an eviction, I believe the statute of limitation, or the statute is that it stays on your record for 10 years. If there is a money judgment that's docketed, that goes up to 20 years. And that's pretty frequent in these cases, even without necessarily a money judgment for like back rent or something, but you still owe the court fees or something like that. It's going to stay there for a long time. So it's important that, if you're able to pay those judgments, it can make that go faster. And the other thing is, unless you actually have to, if the case is dismissed, it does come off after 2 years automatically. Unfortunately, it was going to be lowered to 1 year, and then
Right.
it got changed back to 2 years, which is very frustrating. So it's important to note that, yeah, again, if the eviction's dismissed, it's 2 years. But if the eviction's granted, it can be 10 or 20 years depending on the exact situation.
If the first cause judgment is granted, it's 7 years. If there's
Okay.
a money judgment, it's 20. It's probably worth pointing out now, because this is going to come up a lot, that
Right.
in eviction cases and small claims, they're really two completely separate lawsuits. There's what's called the first cause of action, which is the lawsuit for possession of the real property, the apartment. So you go to court, you could have a trial in front of a judge or a jury on the possession issue as to whether or not the landlord's entitled to put the tenant out. And then when that's over, the case basically starts over a month or two later with a new date in front of the court commissioner to talk about money for a money judgment. So there's an eviction is actually the eviction, and then a separate money case in small claims afterwards. And so there's lots of opportunities for judgments or not that are going to affect the length of time that the CCAP record stays up there. Just beating the first cause eviction or avoiding a judgment doesn't necessarily mean that the case is going to go away any sooner, because you have to finish with the money judgment.
Right. And as we know, evictions can have a huge impact on someone's future ability to find decent housing. So I'm sure you would advocate mediation and lots of other efforts before an eviction is filed, so that people don't have to face those additional consequences. If they're already going through a hard time, that would certainly compound it. I think we're ready to move on. I think we've done a good job setting up what small claims is and what it does. I'd like to hear some of our questions. Annette, what is our first question today?
Our first question. A man wrote to Contact 6 about a problem with a newly constructed home. When he moved in, there were problems with the construction. He asked the business to fix the issues, and there was no action. He then asked for $1,000 reimbursement to complete the work with another contractor. He didn't receive anything. The man spoke with an attorney who recommended handling the case through social media because he said it wasn't worth the hassle of small claims court. The question here is social media a better option than small claims court?
I think this is interesting, and I wanted to get your take on it, because $1,000 in terms of finding a lawyer if someone's not eligible for legal aid, maybe it seems better to find alternative routes. But what are your thoughts on the idea of using social media versus small claims court?
So social media absolutely can be a powerful tool depending on the situation. However, I mean, the effectiveness of anything that's not court is going to come down to the other party and whether or not they're willing to work with you and willing to play ball. And at the end of the day, if they don't want to, the only way to really force action on something like that would be to go to small claims. So if you are trying to handle it with them, with a reasonable reimbursement and, maybe complete that work later, but they just aren't responding, sometimes court's the only way to go. In this particular case, with $1,000, it's hard to know whether or not it's really worth it. The $200 filing fees, whether or not you actually win, whether or not you can collect on that in the end, it's really hard to say depending on the exact content. I mean, the $1,000 reimbursement, he might not be saying,
Right.
It was only worth $1,000. He might be saying $1,000 and I'll be okay. And then also it's important to note that as far as the courts go, and small claims in particular, they aren't necessarily mediation tools. Really, what the courts are generally, not always, but generally looking for are what they're allowed to do. The courts are allowed to issue money judgments. They can do evictions, but they can't force the contractor to work with a new contractor or something like that.
Right.
So as far as what this person's looking for, it sounds like social media might be the better option. And again, like as you said, if you don't have an attorney, you can't afford an attorney, and legal aid isn't, you're outside of those income requirements, it might be the best option to try to handle it outside of court first.
I think mediation would be an excellent approach for this scenario, actually. I know Mediate Milwaukee does pre-filing mediation in housing cases. I suspect that they do in straight money claims like this too. But the fact that it's a newly constructed home and $1,000 suggests to me that there should be a conversation here, because I mean, compared to the cost that they presumably paid for the entire construction of the home, like $1,000 doesn't seem like all that much. And I would hope that they'd be able to, if they had good communication, that they'd be able to work that out. So I mean, I don't think any social media, mediation, and court are not mutually exclusive options. I mean, I'd probably start with communicating directly. Social media posts, if that seems appropriate, given the parties, the company. Mediation, if you can get the contractor to agree with it here, I think would be a really good idea. And then court if none of that works. So
Right. There's also the Better Business Bureau. There's the Department of Agriculture, Trade, and Consumer Protection. And there's Contact6, which we handle cases like this as well. Annette, what is our next question?
Sure. So for the next question, we have two similar situations. In the first situation, a woman wrote to Contact6 about a problem with her paychecks. She said her employer was pickpocketing her money for nearly a year. She took him to small claims court and got a judgment in her favor. The employer never appeared in court, and when the judgment was mailed to him, it was returned to court as undelivered. She is not optimistic about him paying the judgment. In the second situation, a man wrote to us about a rental property that refused to refund his security deposit despite a court order. He says he was told multiple times the check was in the mail. It hasn't arrived. So the question here is, how do I enforce a small claims court judgment?
Unfortunately, this is an issue brought to our attention quite often. Are there steps people can take to enforce a small claims judgment?
there certainly are, and it's not the easiest process. I mean, this is another one of those areas where people can do this without a lawyer. Like it's definitely permitted, and people do. But it's also one of the areas where I think it's probably helpful to have a lawyer giving at least advice on how to proceed here, because there are there are a lot of different ways to collect on a judgment, and it's difficult to figure out which approach to take and in what order. But in all circumstances, I think that the first thing that someone should do when they get a judgment, especially the security deposit case, is to docket that judgment with the court at the courthouse. Docketing is a weird word that just means that you file the judgment, and it's associated with the Register of Deeds. Any real property, any real estate that the debtor owns in that county will have a lien on it for the judgment amount. So like in the landlord example, if the landlord has multiple properties in Milwaukee County, the landlord will never be able to sell those properties without paying the judgment. The judgment has to be satisfied before the property can be sold. So that's not necessarily the fastest way to get the money, but you'd be surprised how often I get calls from closing agents for judgments that were entered years and years ago that I don't even remember, because the landlords finally decided to sell the property and they need to pay off that judgment in order to do so. It costs $5. You go to room 104 at the courthouse, you pay $5 to have it docketed in that county, and then it's there for 20 years, I believe. If the debtor owns property in a different county than where the judgment was issued, you do have to docket it in each county that you want that lien on the real estate. That people who are getting judgments in small claims should do that on every judgment. Like just automatically, you should walk down to room 104 if you're at the courthouse and get that judgment docketed. Beyond docketing, there's a lot of ways to collect on a judgment. You can garnish wages. You can garnish non-wage income.
Is that
like
requiring filing more paperwork?
lots of paperwork, lots and lots of somewhat tricky service requirements on serving that paperwork on the other party, on employers potentially, on renters. The city has garnished landlords' rental income, so they've had the tenants paying the rent to the city to collect on judgments against landlords. Lot of steps there. It can get complicated for lawyers, much less non-lawyers. I suggest the Milwaukee Justice Center in room G9 of the courthouse for advice on collections and garnishing wages and collecting on judgments. But the number one thing I would tell people is docket the judgment, because it might not be tomorrow, but someday you're going to collect on that judgment if they own any real estate in the county.
Right. And there can be more financial implications for a debtor. For example, if they wanted to go out and get a loan, buy another property, they wouldn't be able to do that with a small claims judgment against them. Annette, what do we have next?
Sure. Next, Contact 6 has received 3 complaints about the same contractor. The people allege poor workmanship and unfinished work. One of them was awarded a judgment in small claims court. Recently, the contractor informed them he was filing for bankruptcy. The question: how does a bankruptcy impact small claims cases?
All right. I know when there's a bankruptcy, there's a priority of creditors that are involved. Where do small claims judgments fall in terms of priority for the debtor?
So bankruptcies in general are pretty complicated situations. The biggest thing to note here is that, well, there's many things to note, but bankruptcies are governed under federal law. They're not under state law. And those bankruptcies, when they are filed, they institute an automatic stay on basically all debt collection actions. So what that means is, if somebody files for bankruptcy, you can't try to contact them and try to get that money from them. And that also goes for tenants as well. I'll note that. But basically, once that's filed, you have to go to the federal court and ask for relief if you want to try to collect on that. And the other thing is, this is going to depend a lot on the type of bankruptcy that's filed. There's some that you're liquidating assets as a business, or some that you're paying a certain set amount of your income if you're an individual. So the bankruptcy itself, and in this particular case with a contractor, that could be the LLC, that could be an individual. Really hard to know in that situation unless we had the entire docket and
Sure.
and something like that. So this is a situation where if somebody has filed for bankruptcy, again, unfortunately, an attorney might be necessary to try to help collect on that. And again, do not try to collect on it after the bankruptcy's been filed. I will also note that he said that he is filing for bankruptcy. He didn't say that he has filed yet. So until that bankruptcy is filed, it means nothing. Saying I'm going to do something has no legal weight. Once it's filed, though, the moment it's filed, you absolutely cannot touch it, and can actually get in a lot of trouble for trying to collect on debts that are under the stay. So again, I would probably recommend, if you are looking to collect even somewhat quickly on that, I'd recommend getting an attorney to try to help with that process.
It's also worth noting that if it's a licensed contractor, they're going to be insured. And I'd have to think about this and maybe do some research as to how a claim against the insurance would be handled by the bankruptcy court. Like, I don't know if a bankruptcy discharges a claim against the insurance company if the insurance company doesn't have to pay out under the bankruptcy. So this question actually
Raises a lot more questions for you.
Yeah, it gets real complicated.
Unfortunately, we do come across contractors who are uninsured as
I'm
well.
sure.
And I'm sure people who get this letter in the mail, sometimes you get a letter in the mail notifying you that someone has filed for bankruptcy. I would advise people to fill that out and send it back, and at least put your name on the list as someone who is interested in claiming that money.
Absolutely. If you don't, the only way to collect on debts is to try.
Sure.
If you don't do that, that's a really good way to just get left behind, basically.
And if it's a Chapter 13 or a Chapter 11 deals with business entities, and I'm less familiar with how they work, but if it's a Chapter 13, I mean, there's a chance that it will increase the odds of being able to collect on the judgment, because if the contractor had no intention of paying that judgment in the first place, but then as a condition of completing their bankruptcy payment plan, they have to make payments to all their debtors. Like, if the individual puts in the claim or the paperwork with the bankruptcy court, it may actually increase their odds of getting some money out of the debtor. So,
Sure, they might be a higher priority than someone who hasn't had a case and a judgment awarded.
and even more, I think the bankruptcy court may make paying the judgment a higher priority than the contractor who has made it zero priority. So
That makes sense. All right, Annette, who do we have next? What do we have next?
Yeah. So next, Contact 6 often hears from people facing eviction. Some claim they have been withholding rent because of maintenance issues with their unit. Others claim they are being wrongfully evicted because of complaints they've made or disagreements with their landlord. The question, how do I fight an eviction?
Right. We hear all sorts of reasons why people are in this position. I'm sure you do as well. How do you even start? What do you do if you get that notice or your landlord says, I'm going to have to file an eviction?
So not to do shameless self-promotion here, but absolutely contact the Legal Aid Society of Milwaukee. That should be your step one on how to fight an eviction. The Rental Housing Resource Center can also help as well. We're connected with their resources there. But that should absolutely be step one, is contact legal aid, because we can provide free legal services to people who meet our income requirements. They're higher than a lot of programs, because we do have a little bit more flexibility there. Not everybody, but many people do fall under it, even if you don't qualify for some other programs. So that's going to be step one. Step two, as far as fighting an eviction, it's also important, if you do not show up to court, like we talked about with that default judgment, you will lose. So you have to show up to court in order to fight an eviction. So that is very important. That first court date, that return date, you have to be there on time. For evictions in Milwaukee County, those start at 1:30 in room 400 of the courthouse. So you have to be there on time, check with the clerk, wait for your name, all that type of stuff. Getting into the merits of these cases specifically, regarding withholding rent, and complaints with the landlord. So it's important to note that there is a law for Wisconsin that says, basically, a landlord can still do an eviction even if the retaliation statute only applies if you do not owe rent. So basically, a landlord is allowed to evict you for the non-payment of rent, even if part of the motivation is you've been complaining to me about stuff. So it's really important to note that, that basically you only have a right to defend yourself on retaliation if you are caught up on rent. Now, this is going to get a little bit tricky as well, which is the withholding of rent.
Because there's a right way to do that and a wrong way, right?
And quite frankly, even the right way is still risky, which is very unfortunate. So there's a word here, withholding, that is going to be very important to understand. Legally speaking, there are two different things here that people talk about and what they mean. There's rent withholding, which is where you do not pay any rent at all. And whereas there's also rent abatement, which is where you deduct your rent proportionally to the amount that you are deprived of the normal use of the premises, provided that issue also affects the health and safety of the premises.
Right. So if your contract says you'll have this service and that service isn't working, that would be something you could
And even then, that's going to depend on, does it affect the health and safety of the premises? So as far as abating your rent, if it's in my apartment unit, there's treadmills in the basement or whatever. Just because you don't have that doesn't affect the health or safety. So that is going to be much harder to try to abate your rent for that. Now, if you don't have access to your bathroom or something like that, it's important to note that, again, you can't deduct all of your rent for that. No bathroom, that would be a huge problem, but you're still looking at 50% of your rent at most. Even then, I would feel very uncomfortable deducting that much of my rent, just because you quite frankly, you have access to the rest of the house. And not only that, but what abatement is going to be determined by what the judge decides. There is no good way to determine in Milwaukee County how much to deduct your rent. The best way is to go through community advocates.
I was going to say they might have a formula for that.
They are the best way to do that. Even then, though, we work with them a lot to try to update that list and are trying to get that right. But sometimes, the judges, ultimately it's a discretionary decision by the judges to decide how much can you deduct from your rent. So even if, you're dealing with a really bad infestation, something like that, the recommendation from the city of Madison is something like, depending on how bad it is, 1 to 50%. Well, that's a pretty big range depending on how bad it is. You see 2 rats, that's one thing. I can't sleep because of them because they're running all over my bed, which I have heard of, which is really
sadly, yes,
very sad. Even then, you can't stop paying your rent entirely. And deducting your rent, you do have a right under the statute to deduct it for those issues. You absolutely do. But it does open you up to the risk of eviction. And that's exactly where you really need to contact professionals, either community advocates. The Department of Neighborhood Services is another organization that I would really recommend reaching out to. They have a rent withholding program where technically you pay your rent to the city. That takes a long time. And whatever you do, even if they say, yeah, we think that you're going to be in this program, until you get the official paperwork to do that, do not stop paying your rent. I've seen that a lot where, you're on track to do the rent withholding program. It's taking longer than a tenant wants, and then they do it themselves, and then they get in trouble. So I can't recommend it enough to contact. The best way to fight an eviction: contact legal aid, contact community advocates, contact Department of Neighborhood Services.
Nick, do you have anything you want to add before we move on?
I would just say that as to the maintenance issues, the convictions, conditions issues, tenants do have the right under the statutes to abate the rent on their own, but I don't recommend it. Always find a third party, either the city through DNS or community advocates or attorney, to inspect and advise on what to abate before you do it, because as Mitch said, you can't abate 100%, and it's not always that easy of a determination to make, and it's frankly usually a lot less than the person living there expects to be reasonable. So always find a third party just to be safe before you abate or withhold any of your rent. And then if you are in court, while it's small claims, so you can represent yourself, really recommend talking to us or another housing attorney about defenses and how to proceed, because to be perfectly honest, not everybody has legal defenses to evictions, or even if they do have legal defenses, sometimes they're not nearly as strong as the tenant expects. One of the hardest parts, but also surprisingly, I think, beneficial for tenants. One of the hardest parts of our jobs is when we have to go through and kind of walk through the whole analysis, and it doesn't appear that the tenant is really going to have a valid defense to that eviction. Communicating that to the tenant, and it's a hard conversation, and
Right.
the tenant's often very upset to hear that. But I also think that going to court expecting to have the judge scream at your landlord about what a terrible landlord they are, only to find out that they don't have a defense, and the eviction judgment's granted, and they have to worry about the sheriff showing up the next day and throwing out all of their personal belongings. Much better to have a hard conversation about the likelihood of success ahead of time, and then the tenant can soften that landing as much as possible, try to get as much time as possible, at least plan ahead, so that they're not going to lose all of their personal property and photos and everything in addition to their home. So yeah, always get a third party to help. And it's really important, as soon as you find out that there's an eviction in the works, to seek
help.
some advice and expertise, to make sure that your read is what's going to happen in court.
Okay. Annette, I see we have a couple questions left. What do we have next?
Contact 6 has heard from several people who booked condos in the Wisconsin Dells through Facebook pages operated by the same woman. The rooms were unavailable at check-in and refunds were difficult to obtain. Contact 6 has aired 2 reports on this problem. Multiple people have been awarded judgments in small claims court against the operator. Some judgments have been paid, others have not. The operator recently pleaded guilty to 1 count of theft under $2,500 and is facing 2 more theft charges. The question here is it worth filing a case against someone with unpaid judgments and/or criminal charges?
This is something I find myself wondering on behalf of people a lot, because if you look at the history, you might say, I'm seeing they're not paying their judgments. What's the point? Or, thankfully it's already going through the criminal system. But what would you say? Is it worth still taking that step and getting on the record?
I think it would be. I think that this actually illustrates a lot of the things that we were talking about earlier when we were discussing collecting on judgments, and a lot of the problems with collecting on judgments, but also some of the potential solutions. Docketing that judgment in whatever county the Wisconsin Dells are in, whatever county the condo's in, docketing the judgment there is probably key, because that'll put a lien on those condos. So we know that they have real estate in that county, and so docketing it in that county is going to be really helpful long term. The case could have been brought in Milwaukee, assuming that there was the person lives in Milwaukee, like it's
right. Where the crime
consumer.
occurred, right? It might be where the person lived, or
yeah. We have to separate the crime
You're right.
crime from the civil case, but it's the consumer statutes allow for consumers to pretty much file in whatever county they live in generally.
Interesting.
So they could probably file in Milwaukee County, but then they would have to docket it in the Dells to make sure that they're getting the lien on those condos.
Right. Although this is a bit more complicated because this operator didn't own the condos.
That's
a third party.
That was the next thing I was going to discuss, is that making sure that you sue the right party is also really important, because here, if you sue, I mean, if the lawsuit is against a employee or agent of the owner of the condo,
Right.
You're probably suing the wrong person. You probably really need to sue the owner of the condo, and the actions of this individual as their employee are going to be attributed to the owner through agency law.
Which makes it more complicated, because the owner of the condos doesn't want this woman renting them out either. So it gets very complicated, speaking about these things in generalities. But I do know that it sounds like you're saying they should still file.
They should still file. They should file against the owner and maybe the woman individually, though that's problematic if, well, it's going to depend on the facts, because if she was acting as an employee, probably don't file against her. If she's not, then it becomes much more complicated.
Sure.
But and then the criminal conviction is not necessarily going to recover money for the victims, or at least there may be an opportunity for the victims to recover if the criminal conviction is specifically related to that individual. For other individuals who aren't included in that whose theft isn't included in that criminal conviction, they're not going to see any benefits from the criminal conviction. But it's also worth noting that if there's an LLC involved, or if the owner of the property is separate from this actor who's been convicted, the conviction's not going to matter for the collection purposes.
Sure. It's a very complicated case, so I appreciate you taking that one on. Annette, what is our last question here today?
Sure. So Contact 6 heard from a tenant who has fallen on hard times and is unable to pay her rent. She said the leasing office told her to pay a reduced amount and said as long as she paid late fees until she caught up, she would avoid eviction. She said a few months later, she was served an eviction notice when her rent was past due again. She says she got sick for an extended time and she was waiting for her tax return and disability check to arrive. The question is, how can I avoid an eviction amid hardship?
We all know that everybody can fall on hard times from time to time, and it can be especially difficult when you're someone who's living paycheck to paycheck to begin with. If someone can see this on the horizon, what can they do to avoid it?
The number one thing that I'd recommend is to contact the Rental Housing Resource Center. They do have some resources available, and most importantly, if there aren't resources available there, they are likely able to give referrals to organizations that can help. There's some. I shouldn't even really say this because it's so limited, but the Community Advocates has some limited rental assistance available. There are other organizations that have very limited rental assistance available. There was a lot more during the pandemic. There was a lot more rental assistance. A lot of that money is gone now, quite frankly. So as far as getting caught up on the back rent, there is very limited. Now, I will also note that there is rental assistance available through W2 Wisconsin Works, through Ross or Maximus or whatever your local agency is. But they are only able to provide rental assistance to people with children living in the home. So if you don't have children, I didn't see that in this question. So unfortunately, they won't be able to help there, but they are able to help a lot of people. And they also have pretty hard caps on how much they're allowed to give. I believe it's $1,200 right now. So if you're more than a few months behind, that might not be enough to get you fully caught up, but it certainly helps a lot. And I mean, that's quite a bit of money to help out with. As far as, again, I'm going to back up a little bit here with this reduced amount as long as she paid late fees and got caught up. We do see this a fair amount where somebody says, my landlord said, as long as I pay this, I'll be okay. And then they filed the eviction later. Two issues here. One, landlords are allowed to change their mind. So
okay.
Unfortunately, they may have told you one thing, but things change. You were a little bit short, or you were a little bit late on that agreement, or whatever it was. And if the agreement's too vague, it's usually not enough to actually stop the eviction or stop the proceedings. And in addition to that, in this case, she said that she fell behind later on again.
Right.
So when that changes, so I would really recommend trying to get things in writing if you're able to. That's something that I would recommend, not just in this situation, but every single situation that we've talked about here. Get things in writing, because it's very hard. And by writing, I don't mean necessarily a letter, an email, a text message, something that has a timestamp on it, especially, because that's the only way to prove, really, or it's the best way to prove that you had a certain discussion. As long as I paid this amount, that I wouldn't be at risk of eviction. So again, I would really recommend reaching out to the Rental Housing Resource Center, and even if Attorney Toman was talking about this briefly earlier, which is that sometimes there aren't legal defenses to the eviction. That doesn't mean that there aren't options or ways that legal aid can at least point you in the right direction. So I still would recommend, even if you're behind on your rent and that's the only situation and that's it, and there's no legal defenses, still reach out to us, because at least we can provide you with some kind of resource, or maybe even negotiate with the landlord on a move out date or something like that. We do those a lot, where we get people through the end of the month or whatever they need in order to move. Not all landlords, but many landlords don't want to evict people if they don't have to.
Because it's costly.
Exactly. It's costly for them. They'd rather have you leave on your own. And quite frankly, a lot of them like to pretend that they're doing the right thing. And so it really does help everybody. If you have somewhere to go, if you have family to move in with, something like that, but you need another week, another 2 weeks, another 3 weeks, they often can give you that amount of time. More than that, it's really tough to do that. And quite frankly, I think you're more likely to get it if you contact us at Legal Aid than you are on your own. Not always, but oftentimes we're able to help negotiate with the landlords and with their attorneys to get that extra time.
And I'd like to think good communication with your landlord when a problem arises would be helpful in a lot of situations. I'd like to think there are landlords who would say, hey, you've been a good tenant for X number of years. Thanks for letting me know. Maybe we can work something out. Would you ever advocate just trying to do that communication, or are there some landlords that just won't work with?
Absolutely. You should at least try. The worst case scenario is they say no and you're still in the same spot. But there are a lot of landlords that do want to work with tenants. Quite frankly, unless they work with you, they're much less likely to get paid. It might be motivated by greed, but it still is beneficial to both parties. oftentimes to work something out. So a lot of times, part of what our job is to essentially make that appeal to them, right? Explain, hey, you're going to be less likely to get this money if you just let them catch up over a couple of weeks, a couple of months, something like that, or move out on their own. So it's always good to communicate, always good to talk. There are landlords where that won't work, and that's very unfortunate. But a lot of the landlords are able to at least, if you can provide a solution. I think that's the biggest thing. If they don't see any solutions, if you can't, and there are a lot of people where this person said that they were waiting on their disability check. A lot of times the cases that we're dealing with are people with disabilities or other reasons why they can't just move. So that does make it a lot more difficult. But again, communicate and do your best to try to see what you can do, and reach out to resources earlier rather than later. Again, if you don't ask,
you don't receive.
Yeah, exactly.
Nick, do you have any final comments?
Yeah, just a couple things. I think it's worth remembering that landlords are people too, and a lot of the times this is their income, and so it's a financial difficulty and a quality of life difficulty for both parties sometimes. If the landlord is just squeaking by and can't afford to float the rental income for a period of time. And then I guess my final thought on this question is that and this is almost philosophical, but it comes up more often than I'd like with explaining things to clients. But there's a sense or a hope that that as a society we have a safety net of some sort in the law that is going to prevent sick people from being put out on the street. I think that it just feels like we should have some process in place to prevent that. If someone has cancer and loses their job and can't afford their rent,
Sure.
we shouldn't, that person shouldn't have to worry about where they're going to sleep at night because of that. But that's not what the law says. The law doesn't make distinctions between reasons why the rent is unpaid. The law says that if the rent's unpaid and the right paperwork's filed, the landlord has the right to an eviction. So hardship cases like this can be really, really difficult because most landlords are going to try to do the right thing and work with people, give them enough time to find some place to go. I don't think any landlords want to hurt people or ruin lives, but there's financial considerations on both sides, and the law gives the landlord the right to evict no matter why, no matter what the reason for the unpaid rent. So I guess it's important for people to reach out to the Rental Housing Resource Center or legal aid or someone as early as possible, because they may not have any way to stop that eviction if they can't, despite the hardship. And so softening that landing becomes really, really important.
Right. Well, thank you so much. That is actually all of our questions and all the time we have for today. If you would like to submit a question for a future Ask Contact 6 segment, you can go to fox6now.com and click on the blue Ask Contact 6 button. Nick and Mitch, thank you so much for being here today and for this discussion.
Appreciate how you're having us.
Thank you.
Of course. So thanks also to the people who make this podcast possible, including our executive producer, Sarah Smith, Craig Sween in graphics, chief photojournalist, Kale Zimney, and editor Dave Machuda, who is working our video switcher today. I'm Jenna Sachs. Thanks for joining us.